They come to us to ask us about what recourse they have through legal infrastructure to get justice. And one of the ways is through the public access counselor. Do you all know what the public access counselor's office is? I'm assuming many of you do. But for some of you who don't know, I see some people are shaking their heads. So I don't want to take it for granted that you all know everything about what I'm talking about. But the public access counselor is an office that's been at the AG's office for quite a while. But in 2010, it got enforcement powers. The legislature endowed it with new enforcement powers through the authority to issue binding opinions. So that was new in 2010. Previous to that, the state's attorney had the primary responsibility for enforcing both the Freedom of Information Act and the Open Meetings Act. And that's the milieu of the public access counselor. Public access counselor's office is an ombudsman for those two acts and will interpret those acts. And those acts are, as we know, are utilized frequently. Let's put it this way. Since 2010 to the end of 2013, a 4-year calendar period, the Attorney General's office reports that they've received over 10,000 requests for just FOIA requests for review. Request for review is their name for the appeal process. So the individual who is the FOIA requester, who is not getting the results that they want, not getting the records that they asked for, or perhaps they're redacted a little too much in that person's esteem. They ask the public access counselor through a request for review to take a look into the situation to make sure that the public body is adhering to the law. That's the same for the Open Meetings Act. So for an individual who has knowledge of an Open Meetings Act violation, that person can ask the public access counselor to review that situation and take a look and see is further investigation warranted. So for the Open Meetings Act request for review over the same period, 2010 to 2013, over 1,000. So that's a lot of requests for review at the Public Access Counselor's office. And last time I spoke with Sarah Pratt, who is our Public Access Counselor, she told me that they had a staff of 10 people. So they have some kind of triage system over there. I hope that maybe they can tell us about that a little bit when Anne Spillane is with us after this session. If you're wondering how many of those requests for review are submitted by the media, the Attorney General's office does report out those statistics as well. So roughly 15%, or less than 15% of those 10,000 plus FOIA requests for review are coming from media members. So a lot of them are coming from members of the public. And whether they're coming from media members or members of the public access counselors' procedures are going to be identical in terms of reviewing the facts at issue, whether it's a FOIA violation that's alleged or an Open Meetings Act violation that's alleged. So this project would not be possible without the cooperation of the Public Access Counselor's office. Because there are so many cases, you can imagine that they have a lot of paperwork that they have to contend with. And what you'll find on the Attorney General's website are the binding opinions issued by the Public Access Counselor. Those binding opinions that the Public Access Counselor got the authority to issue those starting January 1st, 2010, are very few in number compared to the total number of requests for review. So, how many have been issued between 2010 and 2013? There have been 44 binding opinions. There are no binding opinions for 2014 on the Attorney General's website yet, so I don't know if any have been issued. I don't think any have been issued in 2014. So what about the rest of those decisions? Well, the public access counselor, in addition to having binding opinion authority, also has the authority to mediate instances and to, especially if the public access counselor misses the deadline to issue a binding opinion, then in that case they have to issue this mediated determination letter, is what they call it, or DL for short, determination letter. You can also call it a non-binding opinion. So what are the differences between a non-binding opinion and a binding opinion? The only difference substantively is that a binding opinion receives deference in the circuit court. So let's say that the FOIA requester, as the case may be, FOIA requester submits a request for review at the public access counselor's office and receives a determination letter. That person, if they are not happy with the determination letter, still has recourse in circuit court. They can pursue an original action in circuit court because the determination letter does not have any standing in court in terms of receiving deference from a judge. Binding opinions, on the other hand, do receive deference from a judge, according to Illinois administrative law. So what does that mean? That means it's a harder threshold for a circuit court to overturn, as long as it's a reasonable interpretation. With a non-binding opinion, the judge can just start anew and not even pay any heed to the determination letter. So that's the difference. But substantively, the content of those determination letters are really no different than the binding opinions. It's the same law being applied, same procedures, how lawyers interpret the law. It's basically what's the plain language of the two statutes. What did the legislature intend behind these two acts? So that's going to be the same, whether it's a binding opinion or whether it's a determination letter. So that means that these determination letters have a wealth of information. And unfortunately, it's hidden because the Attorney General's office doesn't have the staff to put all of these letters online. Now, they did put in 2010, I don't know how many of these pre-authorization letters they put up. There used to be this regime in the new FOIA reform that required pre-authorization when the public body took one of two exceptions in that long list of exceptions in the Freedom of Information Act. And since then, the legislature deemed that that was unnecessary and they asked that for a pre-authorization scheme, which is great. But there were over 3,000 requests from public bodies for pre-authorization to take both the 7.1c and or the 7.1f exemptions in the Freedom of Information Act. One is for personal information that would be unreasonable to reveal about a person, violate their privacy. The other one was for preliminary drafts. Many of those pre-authorization letters are on the website, and they do have value. And I know that I don't know if media members utilize them. I know attorneys utilize them. They're not very easy to navigate, though, because they're all PDF files and they're all separate files. None of the other determination letters, however, are online. So unless someone knows that there has been a determination on a particular issue at the AG's office and they can identify the correct letter or parties for which a letter is written and ask for that through the FOIA officer that's situated at the AG's office that searches for records that the AG office holds. Unless that person can identify that specific record, it's going to be difficult for the AG's office to procure the records. And I know that recently we have a appellate case that was released in Loyola that individual had FOIA'd all of the records that the public access counselor, the Attorney General's office has that interprets the FOIA and the OMA. Well, that's when the response from the public access counselor was, or from the FOIA officer, from the entity was, that's unduly burdensome. Because that's over 10,000 cases, and to give up the information within the timelines that are embedded in the FOIA statute, it would be impossible. So the appellate court affirmed that outcome and said, yes, that would be unduly burdensome for the agent to release all these termination letters, if you will. So without the cooperation of the AG's office, this project that we're announcing to you wouldn't be possible, because they are releasing those determination letters to us, thanks to the help of the funding of the Farmers Foundation, and with our collaboration also with the Chicago Headline Club. We're going to make these determination letters available to the public, and to media members, and to the AG's office in a searchable format, so that this wealth of information is available, and it'll help ameliorate people's understanding of the Freedom of Information Act. It'll assist people in formulating their Freedom of Information Act requests, including media members. And it just provides the public a better understanding of the contours of the provisions and what they mean, these exceptions, these myriad exceptions in the FOIA, and what are the contours of those. So I'm going to tell you a little bit about our preliminary results. So as you can imagine, this is a lot of letters that are coming through our office. They're all single files, they're all PDF files. So there's no simple way of searching them. And they're all redacted. So the AG's office is redacting the signatures of the assistant public access counselor that signed those letters, ostensibly because of the fear of identity theft. And they also are redacting the information about the requester. So it's difficult to know which determination letter may be attributed to a case that was brought forth by a media member or another member of the public or an organization, although sometimes you can tell by the contents of the letter. Certainly for many prisons, the letters that are submitted, the requests for review that are submitted by prisoners seeking records, those are somewhat easier to identify because they're seeking prisoner records. So that's one thing that I would like to ask the AG's office about why they're redacting these names. I personally don't think that the names should be redacted, since these people are availing themselves of the political process, and there's nothing to be ashamed of. The Freedom of Information Act and the Open Meetings Act, I mean, these are our acts that help us in a democracy to be public participants, to be watchdogs, to be reporters, and to keep check and balance on our government actors and on the behavior of our government bodies. Are there any questions so far? I know I'm throwing a lot of information out at you, and I don't know if I'm defining all of my terms. Does anyone have any questions thus far? Yes.
Yeah, you mentioned you started this process. Do you have that online in some format already, which you've already pulled through the PDFs?
We're working on that with the Chicago Headline Club. Yes.
Yeah. Is it okay if I show this?
Yes.
The question is if any of this information is already available online, the sort of bulk of their research is not yet. But it will be. I'm going to show here, if I can manage this. One of the main problems in going through this, and they've been learning this the hard way, is that there literally are letters. It's letters, there's very, very little structure. It's all in PDFs. For anybody who's ever gotten PDF documents to a FOIA request, it's like a JPEG. so the text is not searchable. So part of what they've done is that they are working on establishing an index, which is critical toward understanding what is actually in these letters. And so you're on version 13.
Version 11 has been signed.
Version 11.
Still.
Version 11 of the editorial standards for the FOIA classification of the PAC letters.
Yes.
So
I can start telling a little bit about the preliminary results. Don't look too much at the minutia of what's on the board right now, because that's just the minutia. Let me tell you about what we discovered in the first 100. So, oh yes.
Have you looked into using OCR to create things in files?
yes, so there's a panel later this afternoon where we're going to be showing a software called Document Cloud and another one called AP Overview. Both tools are free. Both utilize OCR for the purpose of extracting text and making searchable index of text. So that is part of the project.
So, because there are so many parameters in these letters to capture and to share in these searchable databases that we wish to create, we've had to create editorial standards to make sure that the reviewers who are reviewing these hundreds, if not thousands, of determination letters are uniformly applying the rules, and we also have to check on that. Right now, we're checking every single one. Hopefully, that will continue if we can. If not, we might do random checks. But so it's been painstaking for the first 100 determination letters because we were polishing our standards, but it's very telling. And I want to tell you a little bit about those results. So first of all, of those 100, 23 of them, the public access counselor ordered that the public body furnish the records. And in 23 other occasions of those 100, the public access counselor pointed to an outside exception. So not only are there exceptions in the FOIA Act, and you'll find that in Section 7 of the Freedom of Information Act, but there are also exemptions in many different acts outside of the Freedom of Information Act. So one of the things that this project will do is create a better list than what exists in the Freedom of Information Act, because the Act does attempt to list out every single outside act that provides an exception to FOIA, but I don't think it's comprehensive, because it's just impossible to do. And so, let me tell you a little bit about what those outside acts are. So of those 23 outside acts that are cited, 7 of them are prisoners that are looking for their master record file. But master record files are not subject to FOIA because the Unified Code of Corrections says so. So these are prisoners who are looking for their booking photos, they're looking for their prison file that's in their master file, and they're also looking for the grievances that they've made, or maybe that others have made, about the entity and institution, and the responses that were made to those grievances, which apparently are also in the master file. None of those are available, they're not FOIAable, because in the Unified Code of Corrections, there's an exemption. There's also an exemption in the Illinois Criminal Code, and this happened in this 100. There's 2 times when a requester was asking for grand jury transcripts, but grand jury transcripts are not FOIAable because there's an exemption outside of FOIA in the Illinois Criminal Code. Another 6 occasions, the requester was looking for reports of elder abuse or child abuse. So 4 of those occasions, child abuse, and 2 two of those occasions, elderlies. At least 3 times, the requester was looking for financial documents, and in those cases, the outside exemption that was cited did not cover the financial assistance that was given to older Americans. So, in one case, the Illinois Administrative Code that the public body was cited to as a way to avoid giving financial information. And in all of these cases, whether it was the Older Americans Act or the Illinois Administrative Code that was used to try to exempt that financial information, the answer from the public access counselor was, you could provide that financial information and redact any identifying information that would show which individuals it applies to. So that was an interesting outcome. In another outside act that was cited twice in this first 100, the Lead Poisoning Prevention Act, and how the Lead Poisoning Prevention Act interfaces with the Code of Civil Procedure. And there were 2 different outcomes in the 2 cases that came forth before the public access counselor. So these first 100 determination letters that we looked at, they all come from the year 2013, by the way. For the one Lead Poisoning Prevention Act, the records were told that they have to be made public. The public access counselor was told the public body that they're outside the scope of the cited exemptions of that act. And it had the records for that case related to property inspections and the proposed remediation plan. In the other case, some FOIA requester was asking for the results of blood samples in the lead poisoning investigation. And those were clearly exempt under the Lead Poisoning Prevention Act. So 23 cases in which outside exemptions come into play. 13 times of those 100 cases, the exception in Section 7.1b, which is where private information released about the person would violate that person's privacy, that trumps the public interest in the information. That was cited 13 times for all different kinds of records. Now, for the records that the public bodies were ordered to furnish, it's kind of interesting to see how those are also grouped. And I'm not saying that I'm not sure why these 100 have these trends, and I think that subsequent chunks of the termination letters that we review are going to have their own trends. But these are just interesting things to know about these letters from 2013. So of the 23 records where the public body was ordered to furnish the records, 10 of those cases were from either the Illinois Department on Aging or DuPage County Senior Services. One of them was from the DuPage County Social Services, and they all had to do with financial assistance information records. And they all had the same response by the public access counselor, which was, you can redact the information that identifies the individual for whom that financial assistance was given, and give up the records. So 10 out of 23 cases. Some of the other public bodies that were implicated in those 23 cases where they were ordered to furnish the records, we have Palatine Police Department, a couple of fire protection districts, Chicago Police Department, Illinois State Police, Illinois Department of Corrections, so a heavy law enforcement and correction representation, but also the Environmental Protection Agency, the Secretary of State, the City of Des Plaines, saying that wrong, and also the Illinois Department of Public Health. So a variety of public bodies that in 2013 were told they had to furnish the records, and for various reasons. In some cases, the public body failed to identify the correct exception when they replied to the public access counselor's answer, a question of why are you withholding these documents? The public bodies are required under the Freedom of Information Act to not only cite an exception or the outside exemption that they are utilizing to keep a record from a requester or to redact a record from a requester. Not only do they have to cite it, they have to provide clear and convincing evidence for why that exception applies to particular records. So they may not just put forth a blanket statement. It has to be grounded in the particular facts. When a public body fails to do that, and that comes to the attention of the public access counselor, then the public access counselor says, you have to furnish those records because you don't comply with the law. Now, do they comply with the determination letters? That would be a wonderful and interesting parameter of these cases that we would love to know. Unfortunately, that would be more time intensive. We'd have to follow up with the public body probably since we don't know who the requesters are and who are redacted. I know many public bodies do respect the Attorney General's office and respect their legal rationales. If they have a differing legal opinion, they may decide that they're not going to adhere to the determination letter since they don't have binding enforcement power, and that might force the individual to take an original action in the circuit court to get something that would be hopefully similar to what the determination letter had. Any questions about any of these results? Yes?
I'm not sure as when the determination letter is issued and when the binding decision. Why would the public body issue binding determination?
I'm sorry, why does the public body bother?
If the determination is there with the court, why would the public body issue only determination?
No, the binding, I'm sorry, the binding opinions are the only opinions that receive deference in a circuit court. So let's say a requester receives a binding opinion pursuant to their request for review, and that binding opinion is favorable for the requester. The public body may choose to pursue a case in court against the Attorney General's office to challenge the Attorney General's interpretation, essentially. And vice versa. If the requester receives an unfavorable ruling from a binding opinion, that requester may take that case to circuit court, but that court is going to give deference to that binding opinion. It's a difficult threshold to jump in court. But with the determination letters, they don't receive any deference in court. There's no they're not legally binding, but the legal rationale are the same as utilized in binding opinion. They have the same value.
So the determination letter comes from the public body, the binding comes from the Attorney General.
They all come from the Attorney General's office. All of these interpretations of the Freedom of Information Act and or the Open Meetings Act, all of the interpretations come from the Attorney General's office, or more specifically, the Public Access Counselor's office, which is in the Attorney General's office. They're the ombudsman. They're the ones who are issuing all the interpretations pursuant to requests for review.
Do you want to also talk about the sort of time frame that you're binding opinion?
Yes.
Because part of the challenge,
Yes.
part of the problem is that there's a very finite window in which a binding opinion can be issued, which means that there are going to be determination letters afterward because they do not make that window.
So we know that the Public Access Counselor is sparingly using its binding opinion authority. The first year in 2010, that office released only 4 binding opinions. In 2011, that office released 7 binding opinions. The subsequent year it was 15, and the year after that was 18. So why so few? That might be a question to ask Anne Spelling when she comes before you. But I can surmise a few reasons. First, there's the problem that the authority given to the Public Access Counselor is limited to a 60-day window, plus 30 days if they ask for a return fashion. But a 60 60-day window outside of from the first day that they received the request for review for Freedom of Information Act. And for an Open Meetings Act, it's from the first date that the Public Access Council initiates its investigation. It's a little bit different when that date initiates for the act, but it's a 60-day window in each case in which the Public Access Council must issue an opinion in order for them to utilize the final opinion power. They can issue an opinion within 60 days of the determination letter. Now, what's the challenge there? These letters go through a rigorous process at the Attorney General's office. They go through several levels of scrutiny. 5, 6, 7 people are reading these letters to make sure that the quality is good, that they're consistent. And I have to say, that's what we've seen. We've seen consistency and we've seen really excellent quality. But by virtue of that process, oftentimes you're going to miss that 60-day window unless the Public Access Council has some inkling through information by the requester saying that this is a really important issue that they may want to issue a binding opinion on to just clarify. And sometimes the AG is open to those suggestions because it might not be flagged for them if this request for review came through their doors as they're getting like 2,500 plus requests for review a year on average. So I want to tell you a little bit more about why the binding opinions might be used sparingly. Another reason I believe is that in order to defend the binding opinions, if they were taken to court, the AG's office would necessarily be embroiled in those court cases. And if the AG's office doesn't have the resources to defend those binding opinions, then that also might influence their decision to utilize that binding opinion power sparingly. I don't know. That's something to ask the answer. Any other questions? Yes.
You mentioned a couple of places where if we had time mostly, we would be able to do more research or follow something up, interpret it, analyze it. It would seem to me that some of these assignments would be of great appeal to either law students for academic credit or for professors doing research or a lawyer who's maybe in semi-retirement or somebody who's done a lot of legal research. Have you reached out to these kinds of folks, and is it a viable idea?
We have actually. We have Citizen Advocacy Center relies on volunteers and interns, and we have a lot of interns. Currently, we have 4 interns. In the summer, we will have 8 or 9 interns, and they assist us. They're legal interns that assist us with analysis of these letters. Paralegals or legal interns that are law interns who are assisting us with this. So we do have teams of people who are looking at this. Part of the problem is we can only also work as fast as the letters are issued by the Public Access Counselor's office because they only have to adhere to a timeline. They're just cooperating with us out of the goodness of their heart. And I also think they're interested to see the searchable database because I think it's going to be a tremendous value to them as well since they don't have the resources to compile some information themselves. And I think they're excited about that. I hope they are. Yes.
Do you know what are the consequences for a public body? Do you know what are the consequences for a public body that is defiant and just doesn't want to give up documents, or with the Open Meetings Act, if it doesn't want to adhere to whatever the termination letter is? What's the teeth in it?
Well, the binding enforcement power in the Public Access Counselor was one tooth that was added to the Sunshine Acts in 2010. Another tooth would be that there are civil penalties in the Act. And for the Open Meetings Act, there's also criminal penalties. So those criminal and civil penalties had always existed even prior to endowing the Public Access Council with those enforcement powers. But they were still not utilized that much. They were hardly ever used before, and they're still not utilized that much just because hand those penalties out when there's truly egregious behavior. We saw that it was in a case down south where a school was like defiant, giving up some records. It was obvious that they were not adhering to any of the demands that releases the records, and so they were found to be egregious in their behavior, and the judge actually fined them $2,500, which for, how much does $2,500 hurt them? I mean, the stigma of getting fined, I think, hurts more.
But does the PAC automatically take that to the state's attorney to bring that action forward?
The state's attorney has its own independent power to enforce the Freedom of Information Act and the Meetings Act. So, for example, in Winfield, when Winfield violated the Open Meetings Act, it was the state's attorney that first approached Winfield to tell them, you guys aren't abiding by the Open Meetings Act, and actually we're going to babysit you all for 6 months to make sure that you do. At the same time, there have been some requests for review pending at the public access counselor for the same meetings. And the public access counselor came out with a determination letter this past January that affirmed the state's attorney's office's interpretation of what was going on in Winfield, and demanded that Winfield shape up their procedures with respect to the meetings. They're independent agencies.
We have 4 minutes left this panel for Phil and Antoine take this. So there's maybe one last question. So in case you guys want to walk around before the next panel. Yes, we have a mic. Give me just 1 second.
Two really quick questions. Are you making the information that you guys are scraping for searches available online in the searchable database as your...
That's the goal. Not as we're doing it, not yet. This is something that we're discussing at the Chicago Feminist Club, and of course, the technology is something that's being hammered out.
Okay. And then the second question is, as a reporter, how do you see reporters using this to bolster their own FOIA requests and stuff like that?
Well, because it's going to be searchable, you'll be able to look at, if you look at some of the parameters that are being collected, it'll be searchable by the type of body. So if you're interested to see generically how do, municipalities do vis-a-vis FOIA, you can look at municipalities generically. Or if you're looking at a particular public body, you're capturing the proper name of the public body, so you can look at how many FOIA requests a particular public body receives, or requests for review, how many requests for review are taken into the Attorney General's office by virtue of the lack of cooperation with the FOIA Freedom of Information Act requests. The body of law is basically the Freedom of Information Act or the Open Meetings Act. And we know that there's vastly more Freedom of Information Act determination other than there are Open Meetings Act determination letters. And then the applicable FOIA provision is another one. So if you're interested to see, hey, have there been any interpretations of 7-1K? That's the one I think is like you can exempt records of institutions that were paid solely by private funds. Like we have to show their blueprints. It's very specific. And you might run into someone and you're wondering, hey, the public access counsel ever interpreted that provision? You'll be able to search through that column. We're also capturing some other data that's not on this spreadsheet. We're capturing who was the assistant public access counselor that signed off on the decision. We're trying to capture a few other dates, not just the date of the PAC opinion, but if it's embedded in the opinion, what was the date that the request was made? What was the date that the public body responded? So just to have a timeline or idea of how long these things drag out. Not all of them have all of those dates, so that makes that difficult because there are no forms. Someone had a question back there. I'm wondering if we just take that one last question. All the way in the corner. Yeah, she's standing right now. did. No, thanks for bringing that up because we all know that it takes forever to go through this process, and a lot of people forego the process because they're so frustrated with that office because they have a backlog of cases. Two things I would say to you: give them a call about your case because they'll flag it in their system and they'll rise to the top. So if you want them to make a move on your case, just give them a friendly phone call to inquire about it. If you're still interested in the outcome. And second of all. Because the process is so long, this is a short stop. This is a quick stop, right? You can go here, see if it's already been decided in the determination letter, look at the legal rationale that was used, go to your public body that you're requesting the record from and say, look, the same thing happened on this date, this public body is the same thing, it's the rationale, look at the documents, and that might sort of prevent a lot of, it might.